welcome back to the House Judiciary Committee this Thursday afternoon, February 19th, and we're going to continue our testimony on H 385, and we'll welcome the network to the table. Thank you, Charlie, for being here.
Thank you for having me. If you will bear with me, I have a slide deck today. I know. I mean business. So
because you're on the screen also.
So I'll bring that up.
I think that was the quickest going to a slide deck that I've seen this session so far. So I'm very impressed already.
Thank you very much. So
was that not true?
It was seamless.
It was seamless. Yeah, it's always this like long thing. Wait, Nate, can you share back with me? Right. So just in the commentary, I've wasted as much time as it would take for you to have trouble getting fired.
Harley Glisserman, Policy Director at the Vermont Network Against Domestic and Sexual Violence. Always a pleasure to be in the House Judiciary Committee and to testify in support of H 385. So I feel like y'all know a lot about the work that we do in our member programs. But one thing that I want to make sure you all know is that economic instability is one of the most significant barriers that our member programs see between a survivor of domestic violence and seeking safety. And we often talk about economic instability and protections in other committees, but we are here to talk about core STEP today. Staff in our member programs support survivors in accessing housing, benefits, financial literacy programs, and more, but there really is a gap where there is very little relief that a survivor can access, and that is when a survivor is forced into taking out debt by an abusive partner. This can be a profound economic impact that shapes a survivor's entire life. So I want to zoom out a little bit, talk about the purpose of this bill, some of the thinking behind those definitions, and then I would be more than happy to zoom in and talk about some of the items in civil legal remedies if that would be helpful. So the bottom line here is that we need comprehensive, clear, and accessible protections for victims of coerced debt. And that those kinds of protections will promote the safety of victims and the integrity of our financial system. We're very grateful to the Commerce Committee, Vice Chair Granning, and this committee for your careful consideration of the bill. So coerced debt occurs in the context of an abusive relationship with a partner, a family member, household member, or caregiver, where a perpetrator uses power, control, and access within that personal relationship to facilitate coerced debt. Financial protections that consider that context are absolutely essential because even with existing laws around identity theft or fraud, they're designed to address that kind of economic offense when it's committed by a stranger and not by a close family member or partner as a pattern of coercive control. So one example of that might be that abuse-related identity theft is disproportionately affecting at-risk youth, including foster youth, whose personally identifying information may be misused by a caregiver or a trusted adult without their knowledge. That harm may not be known until DCF conducts a credit check or the young person reaches adulthood and attempts to access credit for the first time. So all of these kind of instances are covered within the definitions of the bill. We discussed a bit the definition of abuse that is referenced in the current definitions. And we feel comfortable with that statutory reference to the civil definition of abuse because it includes that coercive control language that will address a lot of the co-occurring economic abuse that we see in domestic violence relationships, as well as the behaviors that result in a survivor taking on coerced debt. So most survivors experience some form of economic abuse within their relationship that restricts their savings or restricts their ability to earn money. Many are very low income. So adding debt that is not theirs and that they cannot afford, survivors are really unable to leave an abusive partner and seek safety, to meet their basic needs or the needs of their children, and gain economic independence. When forced debts aren't paid because a survivor doesn't know the debt exists, or the perpetrator doesn't pay on a co-signed loan, or a survivor cannot afford the debt, they face lifelong impacts to their credit that restricts their housing, their ability to further their education. It may restrict their employment in cases where a credit check is part of a job application. It also restricts their access to credit. They may be denied a loan or face higher interest rates. So working on this bill, I often think of two survivors that I have worked with and spoken with who have left abusive partners 4 and 11 years ago. And they are still saddled with significant forced debt that shapes their lives. So just quick contextualized examples of these stories.
Did you say court debt or forced debt?
Coerced debt.
Okay, not.
I know, it's a tricky one.
Thank you.
So this first victim had been in a long-term relationship with an abusive partner. Her partner physically threatened her unless she co-signed an auto loan. She was unable to use the vehicle because he restricted access to the keys. Her partner did not pay on the auto loan. Years after she left, she couldn't secure a loan to buy a home or make needed repairs to her home because her credit was so damaged. The survivor lives in unsafe housing conditions. She's had issues maintaining heat, repairing leaks in her roof because of her damaged credit.
Was she looking to buy a new home? Because you said she couldn't make repairs to her home, but was restricted.
She was trying to seek a living situation that would be safe and healthy for her, whether that was a loan to repair her current home or to move, and she wasn't able to do either. Another victim of forced debt was in a relationship with an abusive partner where even after she left, he was intimidated into paying his living expenses on her credit card. In total, she estimates she was forced to take out over $15,000 in credit card debt. Among many sacrifices, she had to take out a high interest loan herself just to cover expenses for her and her children while paying off that forced debt. These are really heartbreaking stories and speak to the need for relief. So I want to walk through a little bit of the process of this bill. But before that, I want to note 2 data points that reflect really important realities in survivors' lives and shaped how the process in this bill was outlined. So despite speaking to the Judiciary Committee here, one of the most important parts of this bill is that by default, it doesn't require a survivor or a creditor to go to court. A 2025 survey found that 99% of survivors found a barrier to disputing forced debt because they could not access or afford legal assistance. This aligns with testimony that we heard in House Commerce from Vermont Legal Aid, where 94% of debtors do not have legal representation in debt collection processes. Statewide, you know, I'm sure there's a significant need for more attorneys to support domestic violence survivors. And it is really critical that unless a claim of forced debt is being challenged, that you don't have to go to court. Also found that 96% of survivors found a risk of future abuse or harassment as a barrier to disputing forced debt. And there was a recent case in Vermont where forced debt did precede a domestic violence homicide. So measures to ensure survivor safety that are built into this bill, including not being forced to name a perpetrator unless compelled by a court order, are critical. I will admit that I created this slide before I received the latest draft at noon. So please excuse any little disparities. But as the chair noted, I believe you aren't going to be digging into this process necessarily, other than legal burdens. So I have comments on the revised process in this latest draft, but I will save them unless you're interested.
So this is the process where the creditor, the debtor, it goes directly to the creditor.
Yes.
Yeah, because that one is not, that gets into all sorts of stuff with the banks and not us.
Agreed.
So you can jump ahead of that much.
I will, I'm happy to. I do think that this process could potentially be important context for what happens before we get to legal action.
So long as, yeah, so long as we're not speaking deeply, then that's fine.
I will be very high level.
Yeah, if you can help us understand how that moves into the civil penalty, that, yeah,
Absolutely.
thank you.
So the first piece step is that victims of coerced debt need to discover that there's a state law to help them. And it's an unfortunate reality that most survivors of coerced debt will not get to step one. In the several states that have implemented coerced debt protections, service providers are battling underutilization of the law. Still, for the few who can access it, it can change their lives. Next, a survivor needs to collect information for that coerced debt statement, which is the first piece of their evidence. This could mean gaining access to financial records that were restricted from them in an abusive relationship. It could mean getting a record of their credit history. And then they use the information to produce a written statement of coerced debt, which is that narrative describing the circumstances that led to their coerced debt and what that debt looks like. The victim at this point will disclose the name of the perpetrator unless they make a sworn statement saying that they believe doing so would risk their safety. The couple pieces of language in this bill, including that coerced debt prohibited section, early on establishes a private right of action for the creditor to pursue payment from the perpetrator of coerced debt if they are named. They then secure that supporting documentation. So this can look like a police report, it can look like a court order, or a signed and sworn certification from a qualified third party, pains and penalties of perjury. And then if the creditor has a good faith basis to challenge that claim, they can do so in court. Of course, the debtor faces legal action and penalties as a result of producing any kind of fraudulent documentation. And I will note that the process and details of this bill, as you can imagine, based on your questions, are very important. They determine whether this measure is really protective for survivors or whether it's a protection in name only. And the reason why the legal burden is structured in this way is because there are massive resource and power imbalances that keep survivors trapped right now. It is critical that survivors do not have to proactively bring lawsuits to access relief because that is the status quo and it doesn't happen. Survivors are not able to be relieved of that coerced debt. And it is also very likely that survivors may not have access to legal representation, whether they are proactively bringing a suit or whether they're defending themselves in court. And so I think those things are really important to keep in mind, along with the fact that many survivors of economic abuse have their financial information restricted from them during an abusive relationship, and even just accessing the documentation or credit history or their own accounts can be a real hurdle for survivors. So 7 states have coerced debt laws, and we have the benefit from learning from them in how they structure relief and what to expect. As I noted, some states report underutilization of their laws. Some states more recently enacted don't have sufficient data to recognize the long-term impact. But notably, conversations with advocates in multiple states and national experts surface no reports of overuse, of fraud, or negative impacts on financial institutions because of coerced debt relief. I have one illustrative example up on the slide here from Texas, which has a pretty strong coerced debt law. There was a pilot program where a direct services program in Texas received a grant in the Dallas-Fort Worth region. It serves approximately 8 million people, so it's roughly 12 times the population of Vermont. And that program trained domestic violence advocates and attorneys to screen for coerced debt and support survivors who were eligible in accessing relief. Over that 1.5-year pilot, so we even got to the point where we had resources to train people and screen people. They got 111 referrals. 38% of those referrals were identified as coerced debt possible. And they ultimately provided services to 19 survivors to move them through the forced debt relief process. The majority of those forced debts were relatively modest, under $3,000 to $4,000. So I think the takeaway here is that these laws are not going to be used frequently. Even the most accessible forced debt relief process is realistically not going to be accessible for many survivors. For the survivors who can access it, it can be transformative. And it's important to keep that in mind when thinking through the legal burden and process for how this bill will unfold and serve survivors. The foundation of Vermont's bill is a National Consumer Law Center model bill that was produced in 2024. Because they had an interest in supporting a uniform process across the states that were moving forward with forced debt relief. And there are other states like Kansas who right now are looking at forced debt laws and discussing very similar language. If you're interested, I would certainly encourage you to hear from some consumer law experts, either at the National Consumer Law Center or Vermont Legal Aid. The last thing I want to note before I answer any questions is a letter that I submitted as written testimony that was sent to House Commerce earlier this session, signed by 33 Vermont organizations in support of passing this bill. The signers include advocates for older adults, community action agencies, victim services organizations, and it really recognizes the way in which forced debt impacts survivors of abuse in so many areas of their lives, and that we need a strong support and mechanism to address that harm. So thank you again for the opportunity to provide testimony today, and I would be happy to answer any questions.
Great questions. Angela. Yeah.
Like, okay to proceed. So Carly, I'm wondering if I'm looking at page 17, lines 5 through 8. And I'm just wondering if you see do you have any concerns, if the network has any concerns about this potential for predators to pursue action against a perpetrator if they are able to learn the perpetrator's identity. I'm just thinking about how that tips off, could very well tip off the perpetrator and lead to, retribution.
Absolutely. When you noted that question, I thought it was a really great question. My understanding as this language was drafted is that this would only be applicable when a victim discloses the name of the perpetrator, either because they offer it and it feels like a safe option for them, or it is they're compelled to by a court order. And that I share the same concern that you do, and would be interested. I think Maria said that she was going to look into that and follow up. And if there are ways to clarify that, I would certainly appreciate it. There are a lot of safeguards within this law to protect survivors. It would be really unfortunate if that loophole exposed them to risk.
Okay. So something like, I'm imagining even just what, action by a predator against a perpetrator, of course, that, something about if the identity of the perpetrator was, disclosed. It says discovered, and I don't know if that's referring to like just the discovery process or like just discovery, the general definition. So that even the use of that word makes me think that this is permission for the predators to look for it, to try to discover who the perpetrator was. So yeah, I'm really interested in adding some clarifying language there.
So what kind of clarifying language?
Well, like Charlie was saying, like if this only applies in cases where the identity of the perpetrator has either been voluntarily revealed or was compelled through court order, then okay, then But if the identity of the perpetrator was withheld throughout the proceeding,
Right.
and then you get to the end
everything is resolved between the creditor and the survivor. And then the creditor takes it upon themselves to go find the perpetrator and
Right.
reach out to them to get their money. That seems really
So-
dangerous.
So the word discovered suggests action, and maybe we can hear from the judge if that's kind of a term of art, or if we
Yeah.
should say learned of instead, or something. a little more
Yeah,
passive.
Yeah, just,
Okay, now I understand. Okay.
yeah, I just don't know if the intent here was to say, once it's all resolved, then all bets are off and a creditor can go and try to figure out who owes them money and try to get it from them. So I
Well,
want to make
They're
sure.
giving them the right of action.
I get it. There's only something to say about it.
Yeah, well, I mean, but I also think, yeah, I don't think there's any prohibition on the independent action of the creditor.
And I would say, given the sensitive nature of the case, presumably if it is a documented case of abuse, then all the work up to this point to be so careful feels like it could be for naught if there's retaliation.
Right, so I guess the one thing I'd say is that, all right, if the court, if they won't provide the perpetrator's name and therefore have to go to court to get it released, and the court denies that order, would there be some penalty or something against an entity that, despite the order saying, I am not releasing this perpetrator's name, that they've gone ahead and discovered it? Is that contempt of that order or something? So that's a question for Judge Donay when you bring him up there, but
Yeah.
how do they?
So, are we making it illegal for somebody to force debt onto somebody with this bill?
Not illegal as far as a criminal offense, no.
Civil or anything? No, to me, it doesn't make sense because at some point, the court has determined somebody has done something wrong. I mean, that's kind of what we're saying in the bill. But sorry, we can't tell you who. But if you want your money, you got to find out who it is somehow. And it just seems like, I don't know, to me, it seems like there needs to be a penalty on this person so the name can be disclosed. And that there needs to be an order that you need to pay this money back to the creditor.
I think it's set up, I mean, I think it is set up that way, that.
Yeah, but who's gonna pay it? We don't know who they are.
Well,
Unless
that's-
the bankers do their investigative work to find out, right?
Well, unless the court orders that the name of the perpetrator is turned over. So there's a
But they don't
process.
have to necessarily on all occasions. If it's deemed, if the court deems that something has been done, they don't have to say who the person was. To me, if it's deemed that somebody has done something, they need to be held accountable. Because there's a chance they might not be held accountable if they can't be found. So that's
Could you explain again why, what's the sensitivity of not turning over the perpetrator name?
So I do want to note at the top of page 7, there is this language around how coerced debt is prohibited. And that's what results in that private right of action, so that, there are these safeguards built into the bill so that if a victim comes forward, they can maintain their physical safety. And beyond that, a creditor has all legal remedies available to them to go after the perpetrator.
they don't know who it is.
If the survivor makes a sworn statement that doing so would risk their safety, yes. And of course, a court can compel them to release the name of the perpetrator. But those kinds of procedural safeguards, in some form or another, are built into every forced debt relief law it is on the books that I know of. The Department of Financial Regulation did a really great off-session report on forced debt, which I'm not sure if you have it, but I'm happy to submit it to Nate. It goes through some of these safeguards that are just really important for a survivor's safety. There are also some laws in other states that, in addition to liability for the coerced debt, the perpetrator is also liable to the former debtor for the payments that they've made on the debt. So that's another layer of accountability. And then if there's interest in adding language like a perpetrator who is identified as responsible for, say, like a creditor's legal fees or fees related to repossession of collateral, I'm certainly not opposed to that.
Right, no, this is a good education for me. So if everything lines up then and nobody knows who the perpetrator is and it's been deemed that something, of course, that has been done, then the whole burden is put on the financial institution to get their money back when they basically did nothing wrong except put legal papers in front of somebody to sign.
So the burden is first on the survivor of violence who is saddled with this debt in the first place.
First.
And so
That's first.
they have to collect all their records. They have to.
So I'm talking about once the case is all done, not building the case, and once the case is all done and it's deemed that yes, the survivor has the debt. Yes, it was coerced.
Mhm.
And the court, the trial is all done and everything is, all the findings are that, yes, there is somebody who coerced debt,
Mhm.
but we don't know who it is. So then I'm assuming all the burden is put on the financial institution to do whatever they have to do to get their money back when they did nothing wrong except give somebody a loan that came in and qualified for one.
Mhm. So the burden shifting, I think, is really most relevant to the relationship between the creditor and the victim, not the creditor and the perpetrator.
To me, and I don't mean to be brash at all, to me, it's a yes or no question. At the end, does the burden go on to the financial institution?
The financial institution has options about how they want to respond here. And so there are many cases, I'm assuming, and I'm sure Chris can speak to that, where it might make sense to write off the debt, which is something that financial institutions.
But that's putting the burden on them.
And there are also options to pursue the perpetrator of coerced debt. And I think
the
that
financial institution has to do.
that, yes, they will bring a lawsuit. And I will note that when we're thinking about what is possible as far as like resources and access to legal representation, a creditor bringing a proactive lawsuit versus a victim of domestic violence bringing a proactive lawsuit, these are really different situations. And right now, without this relief, the option for a victim that is to get their resources back, to access relief, their most fair option.
I understand all that, and I did get my answer. Thank you.
Okay.
Blame Angela, because when she was speaking, she kind of made that come up. But anyway, that wasn't even my original question.
Can I answer that then
Yeah.
also? I think they have that burden now too, though.
Yeah,
Even without this bill.
Yeah.
Any lending institution assumes the risk of whatever. That's why we go through so many hoops to like get a loan and everything. They're assuming the risk to collect their money.
from the person who signed the loan.
Yeah.
Yeah, and they would have to
Right,
sue
but this
them too.
isn't the person that signed the loan. This is somebody that was found guilty of coercion.
And they might be a party to the loan. They
Right,
might-
well, yeah. there's
But yeah,
variables.
I hear what you're saying,
Yeah.
and I think they have that burden now.
Anyway, my original question is, 7 or 8 years ago, and Chris may remember, we passed a law around social security numbers that people could have their social security numbers sealed so they couldn't be used for getting loans, cell phones, apartments, that type of thing. But if I remember right, you have to request to have your social security number sealed. And the reasoning behind it was I had a constituent whose foster daughter went to get a loan and found out she was like $200,000 in debt because her parents used her social security number and put her in debt. So potentially, and probably that parent did it because they were in dire straits, and didn't have the money to start and, and needed to do it just to get by. That case wasn't it because they bought a house too, but, so anyway, I guess what would the network's job be? Because potentially you'd have a child who's a victim to a perpetrator who is the parent who's a victim with a perpetrator on a coerced loan.
Mm-hmm.
So would that make it a kind of a sticky situation working with potentially with a child and a parent against each other and with a parent with a person who coerced a loan from them? And I don't think that's a too far-fetched of a scenario.
If I'm following you, this circumstance, that would be, it would be abuse related. So, that is economic abuse within a household relationship. So that would fall under the definition of abuse here, even if the person is a youth. That would be unauthorized use of a debtor's personal information, that debtor being the child. And so that's how they would get access to relief here.
Yep.
And I think that process would move forward through this coerced debt claim as any other one would, and they could access, if they needed support through an advocate or through an attorney, that child could access it with us, or they could access it with another source.
Right. So potentially, could you be working with the child against the parent and the parent against the person who coerced the loan?
I don't know if I'm understanding 100%, but would just note that our legal clinic, so for example, it would be inappropriate for them to have that kind of conflict within their practice. Yeah.
Okay.
And one other piece, just on your first question that I wanted to note, is that I think these kinds of questions are exactly why this committee should hear from people who practice in consumer law, which is not me, who can talk about really like how these burdens play out, what these cases look like, and compare it to the status quo.
And even what's in my mind is this question for you. I just didn't say it.
I'm always happy to give it a shot.
Thank you.
Oh, yeah. So thank you very much, Charlie. Very quickly, the qualified third-party professionals, so page 3. So are you hoping or anticipate that, like, in your member organizations, somebody in those groups will be one of those qualified third-party professionals?
Yes, so we would fall under the definition of a crisis worker.
Okay, and so you feel good about the definition here, that you're captured fully and it doesn't need to be changed at all?
Yes, I think that there were definitely some policy decisions that were made by House Commerce that resulted in this exact language, but ultimately we feel pretty comfortable with what we have here.
Okay, great. And then, my only question was the part that we're really looking at, this civil proceeding, is this language kind of borrowed from one of those other states' bills?
I think if Maria's still here, she might be the better person to speak to that. I know, I do know the source of just about every other piece of language beyond the civil legal remedies section. With the exception of the prima facie case language that was from the NCLC model initially and has been preserved throughout this process.
Did you want to respond to that, Maria?
Yeah, I'd have to go back and look
Okay.
more specifically because there were pieces taken from different clause.
Yeah.
And there was some initial language put forward and then, it was worked on and refined a little bit. But I don't, other than the statute of limitations, I think that's pretty distinct to Vermont. I'm not aware of any others that are quite so explicit or long. Usually it's written as not, prima facie case, but it's an affirmative defense, which a debtor would carry burden for it. So there are some differences like that.
Yeah, great. Any other questions for Charlie? All right, not seeing any, we'll go to Judge Dominey.
Thank you very much.
Thank you. Thank you.
Okay.
We have a time limit, am I correct?
5 minutes. We'll see how. You want to rush it, so maybe we'll be a few minutes.
That just helps me get my focus. Tom Zono, Chief Superior Judge. So good afternoon. I took a look at it. My understanding is your committee is really focused on more the definitions and the civil action. So I focused on that. On page 2, where it discusses what a coerced debt is, lines 14 through 16 says, was not subject to either a default judgment or to a final judgment in an action in which the court adjudicated the issue of coerced debt. I just want you to understand that what that means is if there is a pending lawsuit and there is a pending motion for default judgment, it would seem to fall under the definition of coerced debt because it's not subject to a default judgment. None has been issued. And so I don't want to say that the lack of clarity really is what's happening for cases that are pending. And under this, if something's pending, it means it's a coerced debt. It's not excluded.
I'm not understanding that.
So a coerced debt means all or a portion of secured or unsecured debt solely, and it talks about down below, line 14, was not subject to either default judgment or to a final judgment in an action in which the court adjudicated the issue of coerced debt on the merits. So what it says is, if you have a coerced debt, however, there's a default judgment that's been entered, or there's been a decision on the merits, that's not a coerced debt. Okay? What I'm saying is, there's a category that is of cases that are pending where someone's trying to collect that are not yet a final judgment and are not yet a default judgment. And under this definition, they still would be a coerced debt. So just so you understand, that's the policy decision you're making. And again, the trial could be the next day. And if the coerced debt, if that's alleged, then there you go.
So are you saying an option is that it was not subject to a pending?
If that's a policy decision.
But a pending action that considers the issue of coerced debt. I mean, we don't have to say default judgment or final judgment. We just say a pending action.
That could make it clearer that if there's something pending, you don't want to interfere with it, but you may also want to.
I feel like alternatively, maybe like the whole point here is like suddenly a bank is trying to default on you and you're like, oh my God, like I didn't even know about this debt, or this debt was not like, it's like the wake up moment. Now, oh my gosh, this is coerced. I need to exercise this protection.
That's correct. That's a policy decision. On page 3, where it talks about qualified third-party professional on line 16 and defines that individual.
This is page one.
Page 3. What I tried to do was I try to look at these bills and say, okay, what do I anticipate will be litigation issues that you might be able to clear up? Just so you know, as a policy, this would allow brother, sister, current partner of the debtor to write it. There's no restriction on someone having a close personal relationship, indeed being married to the individual, to write it. That's a policy decision.
But that's pretty clearly conflict.
But there's nothing here that provides that mechanism for a conflict to be the judge to say, well, that's a conflict. For the parties to understand that up front.
So would the solution be that you're not allowed to use personal ties or having writing in here some sort of provision that allows the court to weigh in on it.
It might be, I think it's clearer for the individuals who are asserting that the debt is coerced to understand what the limits are to someone who would be filing that on their behalf, so that when they go into the process, they go in with their eyes open, and that the judge doesn't just suddenly say, oh, you know what, I want to look at this aspect, and the person says, I didn't know. So I like the idea of putting some language that tries to identify without a conflict of interest, however you want to put something together.
Okay.
The issues that you were talking about before, I'll try to hit them quickly. On page 16, it talks about, and had quite a bit of discussion about this, with the identity of the debtor, I'm sorry, the perpetrator. That is correct. What would happen is, if they're not identified by the debtor, and the debtor establishes that there is a threat of harm, the safety issue, the debtor is not responsible for identifying the perpetrator. If the court finds it's a coerced debt, the creditor can come to court and say, Judge, we have no idea who it is. Can you direct the individual to tell us, that the debtor? And so the court would then be faced with deciding, if you will, okay, the safety issues here, and have to, I think, delve into the safety issues to understand, because you have a contractual relationship and the creditor has a right generally to try to collect. But if they don't know who the person is, the right that is established for them to collect is really an illusory right. And so the court has to be balancing that. I want to be very clear that when the court looks at this, there's no guidelines. It looks like it's essentially safety, maybe against money. In other words, if it's a $50 debt, is the judge going to disclose? The judge said no. If it's $1 million debt, maybe the judge would. So there's a lot of gray there,
That's what we count on judges for.
and I have no problem with that.
Just make sure, Judge Donnie, are you referring, you said page 16, is this that like subsection D?
It's on subsection C, the top part.
Okay. Oh, yeah,
Then we get to, you jumped ahead.
I did.
Subsection D. It said the presiding court shall take reasonable and appropriate measures to protect the debtor. That's an undefined term. There is no guidance to the courts at all. We address the cases before us, and we don't take the active role to decide what steps need to be taken for that. So that would need, I think, to have some standards for judges to apply. And further down on line 10, it talks about including sealing records. There are constitutional interests to seeing public records. We have public access to court records, Rule 9, that talks about sealing. This seems to create a new sealing that's almost absolute, without reference to the balancing of interests that the judge and the court would generally utilize under public access Rule 9. And so, perhaps you could look at it and make a request after hearing. If you want to set standards for sealing, then again, we already have them in Rule 9. So I point that out because right now it doesn't give us any guidance. On page 17.
So let me just back up for 1 second on that. So when you say standards for judges to apply as far as the reasonable appropriate measures to protect the debtor, I mean, are there standards, or is that just something the court shouldn't be getting into?
We have to decide what someone is asking. Someone has to have a request for relief that is justified or permitted under a statute for us to grant relief. And then we have to take the facts and determine whether or not we're going to grant that relief. Judges generally don't say, well, don't worry about it, I'll decide. This is more of a don't worry about it, I'll decide what the protections are, and it puts a burden on the courts to take affirmative action. That shifts the balance, because the court's role is to be neutral and detached and determined based upon the information it receives. So
the debtor should be presumably making a request of the court for some sort of relief there.
And there should be some standard for what does the legislature, in enacting this provision, want the court to consider when it's going to have this request. If the debtor says we need protection, we have, for instance, how much effort has the legislature put in, even over the past few years, to really specifically define under Title 15, Section 1103, 1104, what we can have, what authority judges have for temporary orders, what authority judges have for final orders of relief from abuse. This essentially is asking a judge to take measures, but we don't know if it falls under stalking, under Title 12 for our authority, Title 15. So the court has no guidance as to what our umbrella of authority is for implementing measures.
So I guess, and this would be a question back to the network problem isn't these protections, aren't these the kind of protections one would seek an RFA? It's like a separate process. I mean, if you're looking for a stay away order or, you know, or do we kind of tie this into that? I mean, with that RFA, it's a little different.
If you want to create a separate standard and a separate statutory framework that identifies what the authority of the court is to issue an order under these cases, you can do that. Otherwise, you have an existing framework under relief from abuse and stalking cases that tells us what our authority is between these two parties. And so if someone says, I have a coerced debt, and they prove it, and they feel there's a risk of harm because they just did this, and they advance this position, they can also seek a relief from abuse. I don't know if it will be granted or not, but they can seek that protection if there's an immediate threat.
And we have coercion as part of our abuse. So it's like, okay.
As you indicated earlier, 1101 1B. It is already there. And then there's a question on page 17. Lines 5 through 8 talk about the statute of limitations for going after the creditor against a perpetrator. And generally under the law, the word discover is a term of art for purposes of statute of limitations. And so the word discovered is okay here, because that's what we understand. It's not learned of it when we have title. It's discovered, knew or should have known. The one thing that's interesting here is, I think Representative Goodnow mentioned it, and that was, would it be helpful to have a more specific date and avoid the argument of when did they learn or when should they have learned? For instance, if it's an action by a creditor against a perpetrator of a coerced debt, one way you could handle it is that the deadline or the date that the statute of limitations begins is the date that the creditor under Section 2495C D1 acknowledges that it's a coerced debt. That's an affirmative date that they would have records of when they send it out, or the date that the court establishes that it's a coerced debt. Those are two definitive timelines that don't give rise, if you will, to argument necessarily about, well, you should have learned earlier. We're giving you 6 years from one of those 2 days.
What was the first date?
The first date I thought you might look at is under 2495C D1, which is on page 8, lines 20 through 21, I believe, when the creditor sends out the letter, the communication notification indicating, yes, we agree it's a coerced debt.
And the other is the court order from here, which is.
Yeah, or the judge finding it as based on the hearing. And my final point is under confidentiality, under F, what I understand, the page line 16 through 21 on page 17, what I understand is that that is intended to be the personal identifying information of the debtor. The only question I have is if the creditor was going to use that to try to locate the perpetrator and they use a third party entity, they would not be able to do that because they cannot disclose it to anyone.
And so that would include a Google search, right?
No, Google search, they can go online because if they're sitting at the computer, they're not disclosing it to anyone.
They're disclosing it to Google.
I agree, but I don't know that Google has, I didn't relate it to a claim is shared, shall not be disclosed without. That is a great legal question.
I will solve it right here now.
I kid you not. So the question
What we
presented,
know about data collection, they are absolutely disclosing that information.
the question the question presented on the appeal would be, is a creditor's uploading of information into a chat GPT search to locate a potential debtor, a disclosure of the information? And
Yes, it is.
2026, we are in,
That is-
if we're in a time where those types of questions are going to have to be answered by courts at some point.
No, I just answered it. Don't worry about it.
So I have one other question.
Well, yeah, that was one of my questions, but also I read that the same way, so, okay, and then, but I'm still, as you read page 17, lines 5 through 8, am I correct in, are you reading it to say whether the perpetrator's name was disclosed or not, whether the court compelled the debtor, debtor to disclose the perpetrator's name at some point or not? The creditor is allowed to seek it out and try to get.
Yes. Yes. I see nothing here that seems to prohibit the creditor from performing their own search.
So that was going to be kind of my question is if they've asked for the perpetrator's name and the court orders or declines, does not grant the order to require the release of the perpetrator's name. That's on page 16, that the subsection C. Would there be any ramifications if the creditor went ahead and on its own tried to figure out who the perpetrator was?
It doesn't appear to be the case. This does not appear to divest the
Just not
creditor.
you're just not ordering the debtor.
Correct. The debtor, if there's a safety issue and the court concludes that safety issue is such that it does not believe on the balance that it should order that individual to provide that name, they would not have to provide that name under the statute. And that does not say that the creditor cannot go out and do their own investigation to find the individual and bring such actions under the statute. So as it wishes.
And on that, can the court grant a creditor a right of action against the perpetrator and then tell them that they can't look for the?
Well, it's not the court granting the right of action, it's the legislature.
Well, I just meant in this court finding. So the court, if the court finds that was coerced, then the creditor shall have a cause of action against the perpetrator.
Correct.
So at that time, so what I'm asking is just like, so there's a court order, it's forced debt, you've got this right of action now, creditor, but because the victim doesn't want this disclosed, I'm now saying, actually, you can't look for this.
So the only thing I differ a little bit on, the legislature, you establish here what the cause of action is. The court's critical finding is whether or not it's a coerced debt. If we find it's a coerced debt, the legislature has established that the person can go to try to collect it. What you point out is that when they try to collect it, they then say, well, we don't know the name. And the judge says, that's the statute.
Yeah.
Well, they said, then we want to have the debtor tell us what the name is. And then the court has to look and see, has the debtor established that the safety concerns, if they don't file the affidavit that Charlie talked about and that information, then it would be able to be disclosed.
Yeah.
That the court could say, yes, you haven't you haven't met the threshold to prevent disclosure. But if the threshold is met and the court doesn't order it, the end result, as you said, is the legislature has granted a right to somebody, yes, you can collect the debt, but within that right is a finding by the court that essentially takes it down a different road and would prevent them from finding out who the person is.
From the debtor, but
Correct.
could the legislature ask the court or allow the court to prevent the creditor from seeking that information anywhere?
That would be a policy decision.
Okay, so we could though.
Well, policy decision, bills like this obviously are going to find their way into court.
Yeah.
So I am reticent to say you can do it.
Yeah.
Because I don't want anyone to construe that as saying that I'm prejudging it or making a legal determination. If the legislature did that, certainly like many bills, there may be challenges on what rights, are there vested contractual rights? Constitutionally, can you take away a vested right? retroactively, things like that. They're going to be the challenges that you're going to be most likely seeing arise in this case. And so my final point is there will be an impact on the courts depending on how many cases. If there's a lot of cases, could be a large impact. If there's not a lot of cases, it wouldn't be that great an impact.
Hard to know.
And like we sat here a couple of years ago talking about coercive control.
Doesn't seem to be overwhelming you guys.
You have not heard me come in and say that we have been overwhelmed with cases. It seems to have been something that is where the courts are able to address the claims when they're brought in. And so we just can't, we don't know.
Appreciate that.
Thank you.
Very much. We'll go to Chris Delia next. Chris, you could join us online there.
Yes,
Good to
sir.
see you. Thank you for your patience and thank you for the excuse to not rush to the floor that you're here.
Well, so are you going to come back to this issue? Because I see fewer of your committee members sitting at the table and you are 15 minutes late for the floor, so.
That's true. So I'm going to ask them to take a look at the YouTube of you, and if we need to have you back, if their questions aren't answered, then we'll have you back. Unless you're available tomorrow morning.
Sure, I can be available tomorrow morning, but I feel like I'm being a bit shortchanged.
Well, that's
no,
what I'm saying. No, that's what I'm saying. Well, we can do it tomorrow morning. That'd be fine. Let's schedule you for, it won't be immediately after the floor because we have a couple other things going on. But I think from what I can tell, the floor is going to be pretty short. Unless people have 40 minutes worth of announcements, we should be done by 10. So we're talking around 10:30, something like that.
Sure.
So let's do that instead then. But you've heard all the other testimony, so thanks for having hung in with us.
Very good.
All right, thanks a lot. We'll see you tomorrow morning.
Thank you.
All right, bye. All right, we are adjourned until tomorrow morning.